Chapter 8 on Mandamus, Injunction and Receivers. 36 and 37 Vict. c. 66, Sect. 25, Subsect. 8. A mandamus or an injunction may be granted or a receiver appointed by an interlocutory order of the court in all cases in which it shall appear to the court to be just or convenient that such order should be made, and any such order may be made either unconditionally, or upon such terms and conditions as the court shall think just, and if an injunction is asked, either before, or at, or after, the hearing of any cause or matter, to prevent any threatened or apprehended waste or trespass, such injunction may be granted, if the court shall think fit, whether the person against whom such injunction is sought is or is not in possession under any claim of title or otherwise, or, if out of possession, does or does not claim a right to do the act sought to be restrained under any color of title, and whether the estates claimed by both or by either of the parties are legal or equitable. As to the practice hereon, see Judicature Act, 1875, Orderly, Rule 4a. A mandamus. The common law remedy of mandamus is for the first time to be universally applicable. Hitherto, as is well known, a court of equity was, by a strange anomaly, incompetent to order, and a court of common law incompetent to restrain, the doing of a positive act. By a still stranger anomaly, a court of equity was able to do, in this respect, indirectly what it could not do directly, by means of what was called a mandatory injunction, a remedy, that is to say, partaking of both the character of mandamus and injunction. It was such an injunction as restrained the defendant from allowing things to remain in their existing, and so compelled him to restore them to their original state. Thus an injunction restraining him from detaining and keeping possession of the books of plaintiff, removed by him from plaintiff's chambers, and from permitting the same to remain away therefrom, or from parting with the books so removed to anyone but the plaintiff, was virtually in order to restore them. b. Any threatened or apprehended waste or trespass. Waste, as contrasted with trespass, was used, it is said, in the old cases, not in the sense of spoliation, but in a technical and personal sense, whatever that means. The Court of Chancery, for a long time confined relief in equity to waste, founding its interposition on the privity between the parties. Lord Thurlow first extended it to cases of trespass. The tendency of the court is to break down the old unreasonable distinction between waste and trespass. Waste is commonly used, it has been said, of acts by persons in rightful possession, and therefore is not in fact waste in the proper sense. But spoliation seems to indicate the degree, not the kind, of injury to property, and if so, might be committed as well by a person in privity of estate as by an entire stranger. c. Whether the person against whom such injunction is sought is or is not in possession under any claim of title or otherwise. This part of the subsection has evident reference to, and was doubtless suggested by, the anomalous state of the previous rules of equity as pointed out in the comprehensive judgment of Vice-Chancellor Kindersley in Loans v. Bettel. The clause appears to refer only to defendants in possession. It would, therefore, have run better thus, whether the person, and c. is in possession under any claim of title or not. As it stands now, it may grammatically apply to defendants not in possession. The words or otherwise, moreover, seem superfluous, for a defendant in possession, but not in possession under any claim of title, is a defendant in possession otherwise, than by claim of title, and his case is provided for by the earlier words, is not in possession under any claim of title. Moreover, the words under any claim of title or otherwise seem wrongly introduced. The foundation of the distribution of the cases, where the defendant is in possession, being the fact not of his having any claim of title, that was the test where he was out of possession but his being in possession anyhow and by whatever means, the court feeling much more reluctance to entertain a suit against a party in possession than where he is not. The question, therefore, which party is in possession, was one of great importance, and often not easy to answer. Now that the Supreme Court is invested with such absolute discretionary powers in granting injunctions as the subsection gives it, it is doubtful whether it will be guided by the principles and distinctions hitherto laid down in the matter, but it is presumed that it will, in order to keep the current of equity authority, as far as possible, uniform? If so, those principles and distinctions, so far at least as they regard injunctions against trespass, cannot be better classified and summarized than they have been in the admirable judgment of Vice-Chancellor Kindersley above referred to, and which may be thus tabulated. The Vice-Chancellor, however, seems to have had in his mind cases of trespass strictly so called only. Plaintiff out of possession, with an adverse claim, seeking to restrain defendant in possession. The case of a claim under privity of title will hardly arise. The court grants the injunction only when there is fraud or collusion, or the acts are flagrant. Plaintiff in possession, seeking to restrain defendant out of possession. Defendant claiming under color of title. The court inclines to grant the injunction, where the spoliation is irremediable. 2. Defendant an absolute stranger. The court inclined to refuse an injunction except under special circumstances, or in case of destruction, and to leave plaintiff to his remedy at law. Or a receiver appointed. As there is no prevalence or conflict of the rule in equity further than that an absolute discretion is reposed in the court, which will enable it to appoint receivers at the instance of a legal mortgagee, it is not within our subject to treat of them generally. Whether the estates claimed by both or either of the parties be legal or equitable. These words apply only to injunctions, and not to the appointment of a receiver.